All right, welcome back, members of the jury. Everyone may be seated.
May it please the court.
Yes.
Counsel. Ladies and gentlemen, grace is defined in our culture as polite, fair, a forgiving attitude towards others. We live in an amazing country, and the beauty of our country is we get to have trials like this. Trials where we get to hear very competent, very well-trained defense attorneys get up here and argue to a jury of his peers that Kirsten Bridegan did not show the grace that the murderer of her husband showed her. That was an argument that you heard from that mouth. That somehow Kirsten Bridegan's desire to hold those accountable and not have the murderers of her husband, the murderers of the father of her children at her funeral for him, isn't grace. She wanted the kids there. But the fact that a man is angry 2 weeks after a widow has buried her husband because she's just being a bitch. The insight of the personality of that man is striking. The only grace is that Kirsten Bridegan wanted someone that loved Jared to be present when his children were notified about his murder, not his untimely death, his murder. And by the way, she went there with her dad, not by herself. She went with her father to stand next to her and be with her during this process. The defense has the, and let me say this before I get, I'm going to say a lot of what the defense says, and Mr. Dreiser and Mr. Hill have done a wonderful job representing their clients within the bounds of the law, and I am not attacking them personally. Maybe a little bit different from what you heard from the other side, but I'm not attacking them personally. They're supposed to do what they're supposed to do. But when they say things like, nothing nefarious, what they're trying to get you to ignore is the starting point. The murder is the starting point. The grace that Kirsten Bridegan showed is the starting point. Nothing nefarious that implicates this defendant. This defendant took this man and turned him in to a medical examiner number on a slab. That's the reality of this case. We don't do it to inflame you, but we do it to inform you. This is what happened. And this is the nefarious thing that occurred. The nefarious thing is not threats within a divorce pleading. The nefarious thing is he ended up with 2 bullets and bled out not knowing whether the daughter, his daughter, was okay or not. That's the nefarious thing. So the analysis has to be what evidence is there that this defendant, is a principal to that act. Your decision is not whether there exists a text message saying, please kill this person for me. Your decision is not whether or not the pickup truck was in a gravel lot near the crime scene. These are not your issues. And we spent hours and hours in closing argument listening to those kind of arguments. That's not the question. The question is whether or not this defendant is a principal to the first-degree murder of his wife's ex-husband. We heard lots about the shoe drop. The shoe drop. You know what the shoe drop was in this case? The shoe drop was after weeks and weeks and months of investigation where Kirsten Bridegan is posting justice for Jared, trying to find out who is responsible when she knows in her heart who it is. But we need evidence. We have to be able to prove it. The police saying, listen, we can't just arrest people because you think they did it. You can't arrest people because you have a bad divorce or bad child custody and you'll always fight. That's not evidence. Motive is not evidence. We have to have evidence. The shoe drop began with the happenstance finding of the tire propped up against the Potomac Avenue address and discovering that, holy cow, the DNA on the murder weapon, the tire in the middle of the road that caused Jerry Bridegan to get out of his car, that was essentially the impetus to his murder, whether it be a firearm or a stabbing, whatever it ended up being, that helped cause the murder. That the DNA on that tire is Henry Tenon. And that Henry Tenon, his ex-tenant, who's so poor he can't afford the rent and had to be kicked out, and he was tired of having him live there without paying rent, killed the victim, and he gave him $10,000 in the weeks after it. That's the ultimate shoe drop. There is zero other explanation from this case. He keeps saying they can't prove what happened. That's what happened. There is zero link between Henry Tenon and the victim. This defendant is the only link, the only hub. The shoe drop is his tenant that he had tremendous contact with over and over and over again, that he paid $2,000, $3,000, $5,000 and lots of other cash payments that we don't really know about, that person killed Jared Bridegan. They don't get any benefit for coming into this court. We didn't know it was going to happen. Stifler and I try to keep our poker faces. We did not know that in their opening statement, he was going to stand up here and say, Henry Tenon did this. No idea that was going to happen. And we 100% agree with defense counsel that a lot of this stuff proves Henry Tenon did it. We didn't know that was going to happen. A tremendous amount of our proof in any murder for hire case, is that the person that was hired has a link to the person that hired them. All that is, they don't get any credit, any benefit, any points for standing up and saying, admit what you can't deny and deny what you can't admit. They don't get any points for that. They have to say Henry Tenon's involved because the evidence is overwhelming it's involved. But they have to deny everything else or the defendant is guilty. Now, a few points about Mr. Tenon. We heard so much of he brings up the jacket and the shoes, and we can't tell you what happened. They stipulated it was Henry Tenon. They keep saying, why did they do all that? The defense counsel says, why did the state do all these things? Why did he argue that? He's saying that Henry Tenon did the crime. Do I know beyond to the exclusion of every reasonable doubt that that's the jacket? No, and the detective just said it was consistent with. He believed it to be the jacket, but we don't know that for sure. It's not relevant. He did it. That's not what's relevant. You know, Henry Tenon may be a lot of things, and one of them is a murderer. You know what? The only two people that knew that little Bexley was in that car were this defendant and Shanna Gardner. And this man, this uneducated alcoholic, spends his money all at liquor stores, you'll have the records, that this man, a desperate, over 60-year-old laborer, handyman, making a few $100s a week. He sees Lexus driving, Toyota Tacoma driving, brand new cars, big spender landlord. And Mario Fernandez turns Henry Tenon from a desperate handyman into a hired hitman. Here's a newsflash. Nobody saw Henry Tenon do this crime either. All this incessant arguing about no one saw the pickup truck. No one saw Mario Fernandez. Over and over. No one saw Henry Tenon. We have some grainy video that later we piece together and go, yeah, that sure looks like Henry Tenon. That was after weeks and months. We didn't know who Henry Tenon was. And if you look at the vehicles, you can never see anyone in any of those vehicles beyond it to the exclusion of a reasonable doubt. And you know how you know that? These arguments you heard over and over and over again. You don't know that that's Kirsten Bridegan and her mother in that car. You know it because they tell you that. If you look at that video when they come in, you can't identify anybody. And that's a clear shot from the police station into their front windshield. There is no video that's going to be able to look into a car and tell you who is inside that vehicle. But this is a still shot from the video that we introduced in evidence. And let me be clear. This isn't proof beyond a reasonable doubt. Okay? But the figure in that vehicle, in that grainy still shot, this is after the homicide, is clearly not a 6'6" black man whose head would be at the top. But it's certainly consistent with a man of the defendant's stature. Well, is that him driving beyond the reasonable doubt? I don't want y'all to get confused. No, I can't say that. No one can say that. It is a shadowy figure of what appears to be a moderately sized individual driving. Maybe even short. The defense argues the defendant is at his house. There's no evidence of that. His phone pinged there earlier and pinged there later, but we don't know what he's doing during the time frame. Right? He says in his non-custodial interview, he says he's passed out high on gabapentin because he has a migraine and never talked to the kids. We'll get to that in a minute. The entire defense was this defendant wasn't seen murdering the person or positively identified in the truck, which is why you hire someone else to go shoot a person. That this defendant didn't leave behind any forensic evidence at the scene, which is why you hire somebody else to kill the victim. That we presented no letter, email, or text from this defendant saying, will you pretty please, with sugar on top, kill Jared Bridegan for me? If you set aside the checks, if you set aside all of the circumstantial evidence of the dry run and everything else. That's also why you and your co-defendants delete messages. It's why you give Mr. Biggerstaff a heads up that he might be questioned. It's why you factory reset a phone. By the way, there's no evidence he purchased another phone. He purchased something at a phone store for $70. Okay? That's what the evidence is. And it might have been a phone. But there's no evidence of that it is a phone. Just could have been. But more importantly, The evidence is he kept his phone. And anyone that has lost anything on their phone or even gotten a new phone, I guess back in the old days, you had to re-input everything. It just so happens to be a few days after his tenant is arrested on unrelated charges. The entire defense is what you would expect to find in a murder for hire case. So then it goes, and you heard this argument, well, Henry Tenon didn't come into this courtroom. Henry Tenon, then the next words out of his mouth are, Henry Tenon has the defendant, by the way, and Henry Tenon, have a Fifth Amendment right to remain silent. And that should not be held against anyone. So if Henry Tenon has a Fifth Amendment right, this defendant has a Fifth Amendment right, apparently, if you can get away with murder if your co-defendant doesn't squeal on you. That's the defense in this case. That's really the defense in this case. Ignore the mountains of circumstantial evidence that points to the defendant and just realize Henry Tenon didn't testify and no one saw him in the truck. We don't have those pieces of evidence, but would you ever expect to have those pieces of evidence in a murder for hire case? By the defense logic, if the killer doesn't testify, it's impossible to prove a murder for hire case, absent a full written confession. Luckily for everyone, the law says that they're wrong. There is no particular piece of evidence that's required. The law requires a diverse group of citizens willing to give up their time and treasure to sit in this courtroom and listen to the evidence and evaluate it fairly. The defense challenged each and every one of you to listen whether or not there's a logical inference from the evidence instruction. Okay? Ms. Stifler, and God bless her, lawyers do it all the time. We like to use fancy language because I don't know if it makes us sound smarter. We exit the vehicle instead of getting out of the car. We say the aforementioned. I don't know why we do that, but we do it. They don't teach it in law school, but we just do it. It makes us feel lawyerly. But she says, logical inference from the evidence. You know what that is? And you know what will come out of Judge Kite's mouth? Is each and every one of you must use your common sense in deciding the evidence in this case. Logical inference from the evidence means common sense. And if you don't use your common sense, then the only cases that could ever be proven beyond a reasonable doubt are those with direct evidence like an eyewitness or confession. Just think about it like this. We talked about in jury selection. Let's just speculate that Henry Tenon comes into this courtroom, he did not, there's no evidence of this, and says, I was paid by Mario Fernandez to kill the victim. What evidence would there be as to bias for Henry Tenon? That he's facing first-degree murder charges? That he has an interest in how the case is decided? That he may be looking for a deal in order to get him to testify against someone that the state wants him to testify to? That's crappy evidence. And if that's all we had, then we would have direct evidence, but we wouldn't have the beauty of the circumstantial evidence in this case. Lady Justice wears a blindfold. And that concept is the concept of circumstantial evidence, that it doesn't have bias. It doesn't have vision problems. Circumstantial evidence speaks the truth. You have an abiding conviction of guilty in this case because it's a marriage of the logical evidence that we have and the gut feeling in your heart. That's what abiding conviction means. It is a marriage between your mind and your heart. Your heart screams to you this defendant is guilty. Jared Bridegan was barely cold in the ground, and this defendant spent 2 weeks after. And this defendant is bragging what a jerk he was, what an awful person his widow is. the only people in the world that knew about the timing, the location, that had a desire for Jerry Bridegan to be heard, that are criticizing him just the weeks afterwards, that got everything that they wanted. They couldn't contain their glee at his untimely demise. You can be entirely convinced and have an abiding conviction of guilt and it be lawful. You're not filling in blanks. You're using your common sense that is given to you by our Maker. And your God-given common sense can be enough that, of course, the hub of the wheel with all these different spokes was this defendant, and he was married pursuant to a contract with the with the Gardners, to kill the victim, hired a desperate handyman to become a hitman, and the circumstantial evidence screams that to you. And that's an abiding conviction of guilt. And that is one which does not waver and vacillate because circumstantial evidence doesn't change. Now, they did a wonderful job of arguing about things we can't prove, which we stipulate to. We don't have someone identifying him or a fingerprint or DNA, but what we have, what they didn't argue to you, is that you have an abiding conviction of guilt. But I want to spend a little bit of time going over what the evidence is that we have. It's been belabored at this point, but I feel necessary because I want to rebut some of the things that defense counsel says. So we talk about motive. By the way, the most smiling, best looking photograph at a funeral I've ever seen. That's what this is at. Where her children are remembering their father. That's what abiding conviction is. Defense counsel talks about the amicable child custody and divorce proceeding. They put out that little thing. Did you notice that when it was closed, it said line 318, that was the number of entries. There were 318 entries in that 8 to 9 years of divorce. This was not amicable. Kirsten Bridegan told you that it would be closed for a couple of months, then open for a couple months, then closed for a couple months, then open for a couple months. The child custody issue, let me be clear, it definitely applies more to Shanna Gardner than it does to Mario Fernandez. Not his kids. But this defendant had financial reasons. Kind of glossed over by the defense. They didn't spend a lot of time with Taylor Crudis other than to, I guess, personally attack us about the questions and keeping her business private. But she was a really important witness in this case because she says two things that I think each and every one of you should find striking. Says it's a hit and run. Okay, that's just weird. Makes it seem like it's a traffic accident. It's not. Okay, whatever. He says he has a contract, not a prenup. She fought with the defense election. They never said prenup. I know what a prenup is. He never said that. And he said it wasn't with Shanna. He had an agreement, a contract with the Gardners, meaning the parents, the wealthy people. He had 75,000 motives to do this. This guy, you have the documents. He got VA benefits and a rent for some slum little houses. That's it. He was working as a maintenance man in a gym. He's driving around $50,000 cars. He gets to keep the money. They sold their marital home. He gets hundreds of thousands of dollars. He gets $75,000 checks at once. That's What's the motive?
Mr. Mizrahi, I think you knocked your microphone off. Okay. Okay.
Can y'all hear me?
All right. Thank you.
Thank you. $75,000 because he had a contract. His parents. That's a pretty good motive. Mario Fernandez is over, so I'm going to go through this very quickly. Hopefully I don't get yelled at too much. You have the video. This is why we put in an interview that wasn't even an interview, by the way. The police asked like 4 or 5 questions the whole time. It was all the defendant going on and on and on and on and on. They said, tell me how things were. How'd you meet Miss Gardner? He saw how things were. This is what he said, which corroborates the whole contract idea. This is the marriage of it. He said, how did you and Shanna get together? He saw how things were with Jared. He sealed the deal with Shanna because otherwise he could not help with the kids. Say anything about love at first sight. He doesn't say we had to be together. He says, I saw how things were with Jared, and I sealed the deal so I could help with the kids. Apparently, Jared's a terrible father because he doesn't want to medicate his children without medical expert opinions, not Mario Fernandez who's Googling. Doesn't want his child's beautiful hair turned purple after he told her, I think your hair is beautiful, you should leave it. I think that's about as common of an argument as you could ever have between a father and, by the way, not a teenager, but like a little 5, 6, 7-year-old. I mean, it's one thing fathers may lose control when they turn 16, right? What are you going to do? But she's like, we don't know the exact time of it, but it's some 6, 7, 8. Father does have some control. So wait a second, you're turning your hair purple? Bad dad. Is a man of faith and doesn't want people without his faith participating and influencing the baptism of his child. That's bad. Oh, and by the way, she's never been baptized. That evidence was presented before you. For as cooperative as they want to make it seem because she bought her a dress, Jared's death ended that little foray into Mormonism that the defendants did not want. I'm confrontational. We want him more custody. I don't like him. And then he says weird things like, I just don't know why he got out of the car, which you can take with that what you will. Not a lot of the details had been released in the media at that point. Was raging. In fact, the details that the police thought was he was shot in the car. Remember, the blood's all in the car. So believing he got out of the car, even though he probably did to move that tire slightly because it was not in the middle of the street. You know, it's interesting. He was raging the night right after Jerry Bridegan was murdered that Kirsten shared that Jerry loved and cared about Mario and Shanna. He actually said that to you. Said it to the detectives, but you get to see it because it's recorded. He said, I just couldn't believe that. What a jerk. He used the B word. How could she say that Jared loved us when he treated us so poorly? He's dead. She's saying, listen, I know we had bad blood between you, but, you know, I love my stepchildren. Can we get along? Kind of thing. He doesn't want that. Another more interesting things, we say around my table in my house.
Ground. Yes.
Ready? You may proceed.
Thank you. And I want to be clear. I think I said it in the beginning. You know, these are my notes. This isn't quote. You don't see the quotes here. All right, you decide what this stuff is. I don't decide it. But this is an argument, and certainly a reasonable inference from his video. I'm using my common sense. You use your own. That he said he was very upset that Kirsten shared that Jared loved and cared about her. He talked about that it was my house and my table, which is interesting since it's 100% financed by his in-laws. That Jared passed away, doesn't say murder. The widow of the murder victim was a bitch. He did say that. He did call her a bitch, or being a bitch. He said she was being a bitch, I think is what he said exactly. And the hardest thing after Jared passed, was realizing that they didn't need permission anymore. Because there was no more split. Another way of phrasing that, this is my argument, not his words, is that they won. I'm going to talk about groups of pieces of evidence because I don't want anyone to get lost on the fact that this location was targeted specifically for murder. And in case it was lost on anyone, this location, when you go to the cart, where we can go back and forth between these two. This is a still from the video, and this is a still from the video at the scene when police were there. There is not, and many of you have been to Jacksonville Beach, and I think there was significant testimony presented on the witness stand. The Jacksonville Beach is a pretty populated place, and that you actually have a road where the only video camera is across a street and some woods. This video camera is not on Sanctuary Parkway. This is on Atlantic, it's Atlantic, right? Huh? America, I knew it was the name. It's on America. So this is a street behind. And, I won't ascribe any supernatural reason for it, but this car driving by, which is on a different road, triggered the video on another road. Who could predict that? That there would be a video from a road behind the woods that would capture the shooting and see the figure. And more importantly, from Mr. Fernandez's case, see the truck doing this little, because remember there's the earlier video where the person with the hand truck at this house triggers the video, and you can see the truck doing that little dry run earlier. Just when I talk about dry run, I'm talking about the dry run on the day in question, showing that the truck has something to do with it. And there's not a darker, more desolate, better location to do this. Only Jacksonville Beach people would know this. You have to scout this. You have to drive around and know this. Henry Tenon from Potomac, I submit to you, would not have figured this out without Mario Fernandez's help. That's full stop. The location, and this also is weaved in with the timing of the whole thing. If there is some motive that we don't know about, or some people with Jared Bridegan we don't know about, despite all efforts, what's the best place to shoot Jared Bridegan on a date night? Where do you know that he's going to be stopped and alone for a period of time? Where do you know it? At the home of the Gardners. And he stops and drops off those kids. That's where he stopped. They don't kill him there. That's too close. They have to find another location to do the killing where he will be stopped and his stepkids will be safe. Only after the kids are dropped off does the shooting occur. The only definite stopping point during the drop-off is at their house. And he had to know it was a date night. How many people in the world know about this? We talk about reasonable doubts, not all doubts. It has to be him. There is no other reasonable decision or reasonable explanation. Let's talk about his. So we have the timing. We have the location that are married, right? for the location and timing, those are the only facts that you had. It's pretty compelling that Mario Fernandez and Shanna Gardner are involved, just based on those things. But we have more because we have his guilty mind. Now, he did a good job in this murder, but he didn't do a perfect job. His phone was not connected. Now, in today's world, the fact that there is absolutely no activity, no phone calls, no TDOA, none of that stuff on a blank screen during the time of this murder, is this defendant is the unluckiest man on the face of the planet. That his tenant that he paid $10,000 for, the timing that only he could know about with date, night, and location, that his phone happens to be not connected in any way, shape, or form. He's either the unluckiest man on the face of the earth, or he's guilty. Unluckiest man on the face of the earth, Stifler put on the usage rates. And the usage rate shows he should be using his phone during this time. Now, does he have to be? No. One piece of evidence, but that piece of evidence doesn't lie. It doesn't have motive. It is what it is. But that's not the only guilty mind. It's because he goes and deletes things. He deletes things right before he's going to meet the police. And do you really think it's because he has pornography on there, like he's going to get arrested for looking at pornography on his phone? If the police don't have anything better to do? He knows what he's going down there for. He knows, he tells everyone, I know why they're looking at me. My wife's ex-husband was murdered. And then the defense stands up there and says there's no evidence that any of those deletions have anything to do with the crime because he deleted them. This is the catch-22, right? You're either, if you get in a plane, if you all remember the wonderful book, Heller, that we all had to read in school, Catch-22, if you get in the plane and you're too scared to fly bombing missions over Europe, then you're sane enough to fly bombing missions over Europe. It's a catch-22. You either don't say anything and you fly bombing missions over Europe, or you say, you gotta be crazy to fly bombing missions over Europe, and then you're not crazy. They actually argue to you, we don't know what the deletions are, because he deleted it. I don't know how to respond to that. He says that we're doing half-truths. We're doing half-truths. They can't show you what the deletions are because they're deleted. Factory reset. We've talked about shortly after Tenon is arrested for unrelated charges. And then we talk a little bit about the unplanned trip, and this is not a major part of our case. But the witness admitted on Zoom, he wasn't on the witness stand, on Zoom, that he forgot to tell all of us that he had contacted him before. Remember, he's like, yeah, I just forgot that like a week before he contacted me. Originally, he didn't say that. He's like, yeah, I just kind of showed up that day. And usually people keep the toiletries from their house. They don't stop on the road unless they leave in a real big hurry. I'll just make those minor points. Oh, and by the way, he came back because he knew they hadn't implicated him in anything. That much he knew, and then he came back. Whatever. It's not, does that prove he did this? No. It's just interesting. So let's talk about the 10 millimeter. Lies speak the truth. You shall know them by their fruits. It's hard to envision a a scenario that we can link the murder weapon to this defendant without the recovery of the murder weapon than what we presented to you. Mr. Dreiser said, why did we present that to you? Because this defendant's very good friend, who he is having sexual relations with his wife the night before the homicide, has a 10mm firearm that no one can account for. It's unfair. We do have a transcript of Mr. Dreiser saying it's unfair that the state of Florida didn't arrest somebody. The criminal defense attorney says it's unfair that we didn't arrest Mr. Bickerstaff. We have no evidence that he's a principal to first-degree murder. We do have evidence that he provided a 10mm firearm to his friend, but without the firearm, how can you prove it? Mr. Bickerstaff make a big deal about the immunity, and then we had to put his son on the witness stand to say, my dad thinks your immunity is bullshit, and he doesn't trust it. That was the testimony. Your common sense, your reasonable inference from the evidence screams to you that this is where he got his gun. Is it a unicorn? Is it one of a kind? No. Every expert we put on that witness stand, including the ATF firearms instructor, says, I haven't seen one of those. Mr. Bickerstaff says, I don't know anyone that has them. And then the defense makes a big deal about the pawns, which was good argument on their part. But he actually doesn't say what Detective John says, which is, oh no, we had the names of those individuals. And we looked into their backgrounds, into their phone numbers, and compared it with all the known evidence that we had, compared it to Mr. Tenon's phones. There's no link between those people and Henry Tenon. The link between Henry Tenon is this defendant. The only one of those three people that told the truth fully was Fred Barton. Fred Barton, former law enforcement, never been in trouble, no reason to not have these guns, no connection to Henry Tenon, no connection to anyone involved in this case, says they brought over a gun cabinet full of guns, both of them, and a week later came and picked it up. The Juan Bickerstaff thing, he seems like a nice kid, but it is illogical that a sworn law enforcement officer would write down the wrong serial number to a firearm that he embarrassingly had stolen out of his driveway. That's a bad thing if your guns go on the streets and you're a police officer. It's not good. And then you write down the very serial number of the firearm that you know is potentially involved in a homicide. The only explanation for doing that is hoping that you'll cover for your dad, and then when you get caught on it, you just say it's a Scrivener's error. I just copied it down wrong. That's the only explanation for it. I feel bad that he wanted to cover for his dad. You heard how his dad lied to him, lied right to his son's face. Oh yeah, I got the gun right here. I'll make it reappear in January. While he's searching for cabinets to store it where it can't be found, when he's searching for 10mm firearms on the day that Mario Fernandez goes to his house. The other interesting thing about the pawns is it shows that people sell their firearms. Again, a screaming piece of circumstantial evidence to you, which is why this poor Mr. Bickerstaff, who doesn't have any money, son works in law enforcement, why on earth would he not sell? Maybe because he thought he wasn't going to get convicted, but certainly after he got convicted, why on earth does he not sell those firearms to get a few $1,000s for them? Because he had them the whole time, because that's what Fred Barton told you. Yeah, they came and picked him right back up. And then if he has the 10 millimeter and he gives it to Mario so that Henry Tenon can murder the victim, can't imagine a better link to a firearm than that one. So some of the top investments where Mario Fernandez could have invested his money. Vertiv Holdings is a global leader in critical digital infrastructure, providing power management, thermal management, liquid and air cooling, and IT management system for data centers, right? AI, we got to build all these data centers so we can do AI. And their stock market price has skyrocketed in the last several years. Advanced Micro Devices is an American multinational semiconductor company.
Hold on.
I agree, it's not
Oh,
inevitable.
no, stop. Let me see you at sidebar. All right, members of the jury, I'm going to ask that you recall, it's been a while ago that I gave you that instruction about closing arguments. What the attorneys say is not evidence, and you're not to consider it as such. However, you are to rely on your own recollection of the facts and the evidence as presented during the course of the trial. You may. Okay.
So, as I mentioned, Advanced Micro Devices is a semiconductor company based in Santa Clara, California. Chips. Eli Lilly has done very, very well with GLP-1s and weight loss drugs that help many of us lose weight. Henry Tenon. Unemployed, but marginally employed. Officially homeless. Handyman. Never operated a business. Whose business plan defense showed you, whose business plan, you make your own decisions on that. I'm making an argument. It looked like it was written on one day. Lots of different dates. And the pen changed. Handwriting. They keep the same pen in trial. Everything seems to have the exact same penmanship, exact same pen, pages and pages of a fake business. Because this is how you launder money. This $10,000 was not a Kickstarter. This was done through criminal acts. This argues that on September 4th, after Henry Tenon was arrested, there happens to be a truck driving by the defendant's rental property that he was about to sell. And that's evidence of a pallet company? There's no evidence of that. There's evidence of a truck driving by with some pallets in this truck. These are the arguments. Carlos phone. Defendant is not good. Not. He was scared. Tell his friend that he had invested in Kickstarter for thousands of dollars. $5,000, I don't care if you're a millionaire or not, $5,000 is a lot of money. He just forgets. Talking about the $5,000 Kickstarter, good luck, that he gives the 63-year-old convicted felon, who, if you look at his bank records or credit card receipts, he's going to a liquor store every other day, makes $300, $400. Disparaging because he's a murderer. That's not the kind of person you invest money in. Looks like it was all the same day as the business plan. Never mentions the $5,000. All this work that he did, there is a memo line. This is what the memo line should say. The memo line should say. Memo lines for the landscaping, for the roofing, were done after Henry Tenon was evicted from the property. That doesn't make any sense to you whatsoever. I can just stay there and live rent free and do work around the place. Doesn't make any sense whatsoever. A couple other points that this makes. Again, this isn't Mr. I'll agree, all Howard agree with Mr. Dreiser's point. This isn't an outbox. It's not about the work. All the energy Mr. Dreiser spent pointing out mistakes, extraordinary errors that we made, but just now, in his closing argument, the Dreiser said that Mario Fernandez turned over his phone on February 8th, 2022. He said, Nick, named Nick, gave the image. Called him Nick. Mistakes aren't what this case is about. It's just Nick. You shouldn't find this defendant guilty or not guilty because the defense attorney stood up and talked about a prenup and said it over and over and over again, prenup, and pulled it out and said it was not months after the case. He bought the car and this car is his asset. The guy was making $36,000, of which they're not driving around a $60,000 Tesla, $57,000 Tesla. So, the defense argues that you can believe Mario Fernandez, I guess, because he knew that there was a call from children Jerry Bridegan made on the night of his murder. Problem is in that same recorded interview, the defendant says, quote, I didn't talk to the kids that night at all. I had a migraine, mannequin, and I was smoking. So he found out about the phone call in the 2 weeks leading up to his interview. Not because he found out that particular night, but muddling the evidence and have to convince you somehow we're misrepresented. Not true. Detective Johns could be the worst detective ever. I submit to you he's not. If I solved this case, I wasn't. Being experienced, yes, and work hard, yes. What does he have to do with this case, really? What piece of evidence are you relying on his credibility? He didn't come to court and said this defendant confessed to me on an unrecorded device, so you have to believe me. This wants to make it seem like the defendant picked up the gun on the 15th and he had sex with the wife, bigger stuff, and they may be. He also could go to 125 with Mr. Biggerstaff. Then Mr. Biggerstaff started searching for potential replacements to the gun he had just given. This is the theme of our case. Take anything from this Hitler and I's closing argument. Could not take away individual pieces of evidence and explain them each individually away. Others than evidence. The state hasn't proven this charge. You must look at this evidence. The payments are still The motive of this case, whether it be child custody or 75 plus hundreds and hundreds of thousands of dollars that this defendant received during the course of his marriage, corroborates the timing. Motive corroborates his guilty mind deletions and wiping of the phone. Corroborates the missing, the link to the missing VIN number. Timing corroborates the link between this defendant and Henry Tenon, who is the shooter. The guilty mind corroborates the location. You get the point. All corroborate each other. You know what this is? This is what you refer to as a rock-solid case. Combination of circumstantial and direct evidence. Is it beyond all doubt? Or beyond close? How many times, before we get to that, I want to make a couple more points. This may have been glossed over, but I want to make this real clear about the January 29th, 2022 trial. Remember how I talked about he must be the unluckiest man in the world? From the time that this crime took place, his phone wasn't bad luck. There's no piece of bad luck. Is that when Henry Tenon leaves, just minutes before, after his phone gets abused, his phone gets to that Potomac Avenue, Henry Tenon leaves for hours. And directly home, the children, assets, where he was eventually murdered, after. Really seconds to minutes, Mario Fernandez's phone. You are the unluckiest man.
Mr. Mizrahi, your microphone. Is it on? Okay. Having a hard time hearing you.
Sure, it's on. Thank you. How many times did we hear, you can't, it's beyond all doubt, it's beyond all doubt, it's beyond all doubt, it's beyond all doubt, you must have no doubt. That's not the real world, folks. And they have to be reasonable doubts, logical, well-founded, sound judgment, not possibilities, not conjecture, not potentially or feasible. The umbrella in Florida in August example is a pretty good one. It's reasonable to believe it's going to rain outside in Florida in the summer. It's unreasonable to think we're not going to have court tomorrow because of that. It's possible, but it's not reasonable. Was Jared Bridegan murdered? Did the defendant want or intend for him to be murdered? Did he incite, assist, or otherwise cause the murder to happen? That is your question. It's right here.
Okay. Members of the jury, the attorneys, what they say is not your instruction on the law. You may proceed.
You decide whether that's wrong. Right there, same thing. Your doubts, if any, that are reasonable, meaning logical, well-founded doubts, meaning you don't have an abiding conviction of guilt, must go to the elements of the crimes charged. They're up here. And then remember, the death caused by the criminal act of Mr. Fernandez goes to the principal instruction. He doesn't have to pull the trigger. The tenant pulled the trigger. But if he has a conscious intent that the act be done, did the defendant want or have a conscious intent that the act be done, and help in some way by paying him, by showing him what date night was, by picking out the spot, by driving the truck away, all of these things overwhelmingly show you that he's a principal to first-degree murder. The defense made lots of arguments about how there's no direct evidence, right? Yet we spent hours of this trial looking at Home Depot buckets and people carrying things into a house. Remember all that? No one saw what happened in that house. The defendant's argument the entire time, and Detective Johns didn't want to say what was going on in the house because he wasn't there. He was trying not to give his verdict. He was trying not to give his opinion about what was happening in that house. He's just like, well, yeah, it appears like it's work going on in that house. The defendant, for hours and hours and hours on the cross-examination of Detective Johns, shows you the power of circumstantial evidence. No one saw any tile work being done. No one had any eyewitness inside of that house. What we saw were circumstantial pieces of evidence that work was being done in the house. And that is exactly what we have here, is an incredible amount of circumstantial evidence that proves that the defendant had a conscious intent that the act be done and paid for it and helped plan it. Defense says there's no evidence that Henry Tenon got the gun, except for the fact that Henry Tenon used a 10 millimeter to kill the victim, except for that minor little detail. It's a relatively rare gun, and the defendant's good friend that he had sex with his wife the night before the killing cannot account for his 10 millimeter, even though he should have to account for it. The combination of all of these pieces of evidence should leave you no doubt. Now, this is a very important case. And defense counsel said to you repeatedly that this defendant stands accused of first-degree murder. He 100%, because he's charged with first-degree murder, he is afforded all the protections and guarantees afforded to him by the laws of our state. And it's important for him. It's important for Kirsten Bridegan, whose grief has so scarred her heart that she wears the scar as a proud badge of the love that she shared with her husband. It's to the kids. It's really important. AB, LB, little Bexley. Little Bexley that said, I saw a boo. Well, the police just helped my daddy. These truths about this case, about how this defendant turned Jared Bridegan into a medical examiner number, are all important. Do you have that marriage of your heart and your mind, an abiding conviction of the guilt that the defendant who received hundreds of thousands of dollars during the marriage and whose wife got the custody that she so desired, that this defendant who knew the timing, who knew the location, who is the only link to the murderer, who has a direct link to a missing 12 millimeter, and has a conscious intent that this happened and benefited from it, and then consciously deleted the evidence of it. Is he held to account? Or does he just get to walk away because Henry Tenon has a Fifth Amendment right? Does he get to go home because he paid somebody else to do it? And then deleted everything he could after the fact. It's important. I submit to you it's easy. Because Lady Justice and circumstantial evidence can't have bad eyesight. It can't have a motive to lie. And it speaks the truth about who's involved in this case. That's why we have so many of you to decide this case, is because each and every one of you gets to contribute your abiding conviction, your thoughts about how this case should be defined. It is important, but it's not that hard. This defendant, person with the motive, person who paid for it, the person who knew everything, the link to the killer, not the unluckiest man on the face of the earth. He's just guilty. Confident that when you marry your emotion, your heart with your logic and the law as the court instructs, you will find that truth. You will hold this defendant accountable. Thank you.
Thank you, Mr. Mizrahi. Members of the jury, the hour is late, and we do all from both sides appreciate your time and your willingness to push through. It is so important that you all understand where we're at, which is you've heard all the evidence, both sides have rested their case, you've now heard all of the closing arguments, and we are trusting you that each and every one of you will abide by this court's order, that you won't research anything, you won't look up anything, because the last piece that you need is the law. And so I intend to give you that law in the morning, okay? First thing, 9 a.m. So you all cannot talk about this case with each other. It's not time to deliberate. Instead, since the hour is late, then it's time to rest. And so that's what we're asking you to do. Come back refreshed. Follow the court's orders. Will all of you all agree to do that if you could answer out loud? Yes. All right. See you in the morning. All right, please let the record reflect that the jury has left the courtroom. Anything we need to take up? I'm going to email the copy of the instructions. I'm going to do another read of them if you all would do the same. So if you catch any typos that I didn't catch during the charge conference, if you will let me know at about 8:30ish so I can make those changes and then get them out to you.
In doing some quick research, Your Honor, I think the court has to discharge the alternates, and they cannot sit at a later time.
Okay, thank you. I thought that. I think you can do it in death penalty cases because it's a different issue, but I appreciate the research. So The question to me right now is, let's say everyone can be seated. I'm sorry, I forgot, I got caught up. So the question right now to me is that, let's say that all 16 come. Do you want them all 16 to listen to the instructions, or I can bring out the 12, excuse the 4 alternates, just to make sure that we get them all down here?
Yeah, I mean, it's 6 for one, half dozen the other. I think they may want to listen to the instructions. You can sit the 12 in the back, start seeing the evidence back, and then do your long recitation about how thankful we are for the 4's time, as opposed to just sending them home before we do all that.
I'll just do it the normal way. It's fine. So they don't feel like they totally wasted their time. Well, no, they get us to finality. There was a lot of work and a lot of moving parts. So the other thing, I think, so like I said, I think the instructions are about 30, about 30 some pages. If this is to the gallery, because of the reading, because it's technical, I don't allow in and out. So if you all don't want to come for the morning session, that's all that's going to happen. But once I start reading, I lock the doors. And so there is no ability to go in and out. So you have to make a choice, okay? So obviously it'll be live streamed, so you can watch it that way and you don't have to be trapped in the courtroom. But I can't have the jurors, and it also distracts me from the reading. So just to let you all know so you can make your choices overnight, okay? All right, and I want to thank each side for your time and your attentiveness to these proceedings. Your professionalism was appreciated by this court and the parties. The court's adjourned.